Are you curious about the probate timelines during this COVID pandemic? Well, stick around because that's what we're talking about today. Hi, I'm Charlotte from the Volsch team. Welcome to my channel. And if this is your first time here, I'm a real estate broker, certified probate specialist, and trust advisor, helping the many administrators and executors in the Inland Empire and the many cities of including Redlands, Loma Linda, San Bernardino, Fontana, Rancho Cucamonga, Ontario, and the High Desert. And every week I bring to you tips, insights, and updates to help you gain clarity during this time of overwhelm and sometimes confusion. So when you're going into a probate which has its own overwhelm and you're wanting to finish up all the details of a loved one's estate, I'm sure you want to have a clear understanding of how COVID may affect the timeline process. So be sure to stay until the end because I'll share a current situation with a client I'm working with right now that's had a drastic change in her timeline. So let's look at the full California probate timeline. It can take between 7 to 12 months for the process to be complete. And the process starts when a petition for probate is filed in the probate court in the California county where the decedent resided at death. The first court date is 6 to 8 weeks later and can sometimes be up to 3 months later, especially now with the partial court closings. Now, before the first court date publication is arranged, there in the local newspaper is the publication of a general circulation, and notice is mailed to all the interested parties that may be creditors. And at the first court hearing, assuming everything has been done correctly, the judge should issue an order approving the petition. And with that order approving the petitioner can get the letters of administration. The letters of administration are the most important document in the probate. And during the next 4 months or more, the personal representative will use the letters of administration to take care of the decedent's affair because it shows that they have a full authority to do just that. This will include gathering assets, dealing with creditors, paying taxes, determining who the beneficiaries are, and after the 4 months, the personal representative can prepare and then file the final petition. Again, the court date will likely be 6 to 8 weeks out. And at the time of the final hearing, the judge will hopefully sign the final order and the case is basically done. Checks cannot be written. They can now be written, and the only other thing left to do is to get the receipt signed by all the heirs or beneficiaries and then file for the final discharge or the accounting. The final discharge is then given to the bond company if there was one so that the entire file can then be closed. This is the ideal timeline if your attorney and realtor are working for you to meet all the deadlines. Sound straightforward? Right. Well, here are a few important factors that may affect the length of the probate timeline, pre and post-COVID. Number one is the size of the estate. The larger and more complex an estate is, the longer it takes to resolve all the confusion and completely distribute every element of the estate. And number two is the number of beneficiaries. The more beneficiaries a decedent has, the longer it takes for the executor to get around to completely distribute the estate and also to hear back from every beneficiary when the notice of proposed action is filed. And the third thing is family issues and strife. Will contests, arguments, uncertainty, and fundamental disagreements between beneficiaries can massively complicate things. Inheritance is never a smooth subject, but the larger the family, the more difficult things can get. Other factors to consider include the nature of the decedent's financial dealings and the extent to which they do owe money to creditors. And that will all be revealed in that first 4-month period. So thank you for sticking around. As promised, I wanted to share with you a recent probate delay situation I'm currently working with. And in some probate situations, tenants will need to move out. And with that, a notice has to be given for that to happen. Property repairs need to be completed. And finally, the property sold. With COVID and with the current state of affairs, the governor has a no eviction order until the state is in a non-emergency status plus 90 days. What that means is my client D cannot evict the tenant from her loved one's property until that order is lifted plus 90 days per the governor. This has been an added overwhelm to my client. She is not receiving any rent money from the tenant, and the mortgage and bills still need to be paid. The beneficiaries cannot receive their distribution until this is all finalized. With my expertise in the probate process and the direct contact with her attorney, we will be able to quickly move on the eviction notice once the order is lifted and we're able to serve 90 days after. Then we can move forward to a successful sale of the home and finalize the probate. Each probate and trust property sale I've assisted in has been uniquely different. And because of my years of expertise, I have been able to anticipate and head off issues before they arise, but no one saw this one coming. If you found this video information useful, give a thumbs up, subscribe, and comment, and watch this next one. I think you'll find that useful as well. And I'll see you next time.